6. Okay, we are here today, back on record on this one for a pretrial and a couple of motions that were filed. We have the names of our participants, please. Where's our guardian ad litem? Hang on,
Ariel
Mr.
Berger
Berger.
here as the guardian ad litem.
Thank you.
Ms. Saja Thomas, counsel for the department.
Attorney Your Honor, William Amadeo, P7619, for also counsel for the department. To my left is my worker. State your name.
Chelsea Grant with the department.
Good afternoon, Your Honor. Alex Lizahu on behalf of the respondent who sits to my right.
And your name?
Matthew Higgins.
Thank you. Very good. All right. Any preference on which issues we're taking first, gentlemen?
Your Honor, could I suggest that we get the two motions out of the way since they've been addressed by effective counsel today? Put that on the record, is that fair?
Any objections?
No, not at all, Your Honor. And is non-responsive mother Leanne Higgins present on Zoom or not?
She is. While she's logged in, could you confirm that you're here, Ms. Higgins?
I am here.
Thank you.
I think that's everybody just for housekeeping. Do you want me to make a record?
Yeah, I'll correct you if you're not.
So based on the two motions, Your Honor, we have no objection to the discovery. Obviously, you would be the gatekeeper for what's admissible, but if Mr. Liza wants to dig up whatever discovery he feels is relevant, there's nothing in the department's possession that's not been provided to him, other than the CAC interview, which we're going to do under protective order. I'll discuss protective order briefly, but I have no objection to his motion. If he feels something is relevant, obviously I would need to review it, and you'd have to determine if it comes in the trial, but I have no issue with his discovery motion. I just don't have possession of the things he's requesting.
Okay. Your position, Ms. Berger, on the discovery motion?
I take the same position as Mr. Amadeo, Your Honor.
Okay, does that help you resolve that one, Mr. Lizahu?
It does, Judge. I didn't want an issue of interpretation coming in here arguing about something. I wanted my third-party discovery. I did already make my request for a discovery from opposing counsel, but as I indicated in my pleadings, there were other things I needed. So yes, if Mr. Amadeo has given me everything, how can I ask for more? But there are other parties I might be interested in getting discovery from.
All right, I'll look for an order on that whenever you're ready to provide it, either under the 7-day or by stipulation once that's directed.
Thank you, Your Honor.
As for the second motion, Judge, it is my understanding, and Mr. Lizahoe, please correct me if I'm wrong, that you want an expert to view the CAC interview?
Well, so the order as written and signed by Your Honor prohibits me from even showing it to my client. And I don't know that that was the intent. I don't think it was, but I'm not going to play games with your order. I'm going to do exactly as Your Honor says. So I'm looking for several things. Number one, to be able to share it with my client, which opposing counsel is okay with that. Number two, they've indicated no issue about me having the CAC interview transcribed. That's great. We're all on the same page. And I've agreed that to the extent I'm going to be using an expert on the CAC interview issue, I will share my expert's curriculum vitae with brother and sister counsel so that they can see that it's a qualified person to be able to testify on the issue. And they likewise have agreed to provide me with a curriculum vitae of whomever performed the CAC interview. And I'll have one other point, two other points, Judge. First off, I've asked brother counsel, is there more than one person that you're going to be using to establish any evidence regarding the CAC interview? He's indicated to me no. So that I'm not worried about any other CV than the one he's going to give me. And the other point I needed to make, Judge, I have not received the CAC interview until a few moments ago. So I have not seen it. I haven't reviewed it. I know nothing of it, but I want to represent to this court that I have not had it before today.
I'll respond to that when appropriate, Judge.
Have we had the order released?
The order, we just got it. When did we get it? Today?
Your Honor, if I may, you had signed this order in September 1, and given that it was prior to Lenawee Advocacy Center changing to their electronic form of sharing these video recorded statements, we had to wait for the thumb drive to be produced. And so I got that at the end of September, and just today I have provided that to Mr. Lizzo. As it relates to the language in the order, there's a specific citation to the statute, MCL 712A.17D subsection 7, which specifically states who is entitled to review that video recorded statement. And that language is not entirely reflected into the order. And I believe that was the point of confusion for Mr. Lizzo, but because of that citation, I believe it's encompassed in there. And we have no objection to his client reviewing that.
And I guess the only other thing, Judge, certainly his client can view it. The big issue of his motion is this expert. I don't know who the expert is. And quite frankly, Your Honor, you're the gatekeeper here, not me. So no matter who his expert is, I can't just stipulate to that. If Mr. Lazo wants an expert to study this CAC and come in and testify, we need to have a Dolbert hearing for you to determine if that expert is actually qualified. I have no objection to a Dolbert hearing, but I cannot stipulate in good faith to his expert. Well, number one, I don't know who the expert is. Number two, I'm probably not qualified to determine what their CV is. And three, the court will say, you're the judge of this. You determine if an expert is admissible or not. There's no way I could stipulate to that other than to say, I think we need a Dolbert hearing to determine the credibility of his expert.
Would that be before this person is able to look at the CAC interview?
That's a concern Mr. Lazo has. And I think it would be before, because if they are an expert in this field from past experience, they can be an expert without viewing this. I think it's the determination of the court, is this person even able to be an expert based upon what their CV may say for them to study it? I don't think they can study it before being determined an expert. I can't think they use the CAC as a tutorial to determine if they should become an expert. Either an expert or not. They either possess those qualities or they don't. Once this court determines they're an expert, if that happens, then they could view whatever they want if that's acceptable. But I don't think they should be able to study and say, okay, I'm an expert because I see certain attributes. They either got to have those attributes or not prior to the study of the CAC.
Mr. Lizzo, that would seem reasonable to me, given that the statute does keep close to the vest on the number of people who are entitled to view that CAC, and that would honor, it seems to me, the spirit of that particular language in the statute. What are your thoughts?
My thoughts, Judge, of course, I'm going to share the CV with brother counsel, and I'm not going to waste my time finding somebody to be an expert unless they're qualified. And I'll look at it and I'll study it. And if there's an issue, we'll bring it before your honor. But yeah, I don't have any issue showing the CV of the expert to brother counsel before viewing of the CAC interview. It's a very simple process. I got the CV, I send it to him. Now he calls me and says, Alex, you know, your expert, it was educated in Indiana instead of Michigan, so I opposed the use of this person as an expert. Well, then we come back before your honor, and your honor will decide that. I don't have an issue whatsoever.
Well, I think what he's saying is that I would need to give you essentially permission to allow this person to review the CAC and do that analysis first.
Well, I thought the permission was from brother counsel, but if your honor wants us to send the CV to your honor first, I don't have an issue with that either.
Thank you.
I wouldn't want somebody that's not qualified to do it, of course.
And I guess, Your Honor, the only point I'm making is you'll determine our qualification, not me.
Yes, get to have to. Is Berger, any thoughts that you'd like to share on this conversation?
I have nothing to add, Your Honor.
All right, so to me, that sounds like we may need to build that into the schedule moving forward. Do you have any idea who you're going to want to use as your second evaluator?
I do, but I want to speak to the person first.
Okay, all right. Well, part of what we're addressing today for purposes of pretrial is, of course, the timeline that we have set for trial. Is this going to impact our current dates that we have set?
I believe it might, Your Honor. Moreover, I've been working up my file, and I believe I'm going to have more witnesses than I originally anticipated. And I don't know that 3 days would be enough, so.
As of right now, yes, I have the 3 days in January.
Right, Judge.
Wait, I'm sorry, you don't think 3 days will be enough for this trial?
No, I don't.
I've tried capital cases in 3 days with 12 jury picks. I really find hardly we won't get this done in 3 days, but I'll defer to brother counsel. Can you give me an idea how many witnesses you think you're gonna have? That would take more than 3 days?
Actually, I have a list, I'd have to pull it, okay, like 8 people on the list.
Can I just ask, how long do you think this trial will go? If you had the
I
ballpark,
don't know, 4 or 5 days.
You will find that I do challenge on whether or not we're going to be hearing the same sorts of testimony more than once. So I would just encourage you to keep that in mind, that you know, if you have 3 different witnesses that are going to be testifying to essentially the same facts or circumstances or similar ones, then you may have me challenging you on that point, as well as I'm sure your fellow counsel. So I don't know who your witnesses are or what they intend to do, but you may want to consider consulting with your fellow counsel prior to, in order to make sure that you don't have that issue confronting you during the trial.
Not interested in duplicativeness whatsoever. But to the extent a particular witness can offer evidence that I believe is material to the case, I do intend to introduce that witness.
I guess, Your Honor, just to respect your court and judicial economy, I may be asking for offers of proof before we determine how many witnesses, because respectfully, it sounds like brother counsel has a ton of witnesses they intend to put on. And my concerns with cumulative evidence, I'm going to challenge everything. I don't know. But this is the first I've heard it. We're going to need 4 or 5 days for this type of trial. And again, I'm trying to bring my experience in. I've done murder cases in 4 days. So I find it really excessive that we would need 5 days for this trial. But if that's the case, I would request offers of proof if it's going to be witnesses that have nothing to do with the discovery.
That's also something that I would want to have settled before we bring the trial or the jury in. I also don't want to commit our community members for more days than we need to, or waste their time as if there's an argument or a battle about what witnesses are going to be there. So I simply suggest we build that into our final pretrial and look through that witness list and have that ready to go. If there's a disagreement on which witnesses are going to be called in front of the jury in our final pretrial, if that sounds like it's something that we can accomplish.
I have no issue with that, Judge.
Mr. Lizigu?
Yeah, we can do a witness disclosure. That's fine. I'd be more than happy to. And as discovery moves forward, I might have additional witnesses, but I don't mind a preliminary witness list. I think that'd be fair. I think it'd be fair to me too, because then I know who they were planning to bring.
So I guess the last issue is your client has a right to trial within 6 months. It would be quicker than that, but at the latest, it would be 6 months. And if we go out past February 11th, or around that date and time, then that's going to be beyond your statutory right to a speedy trial. Is that going to be an issue?
I'd have to consult with my client, Judge. I do have my calendar with me. I have open dates in January as well. So I'm willing to work with the court, but I'd have to consult with my client on that.
All right, well, respectfully, Your Honor, if we're going to do a Goldberg hearing, we're asking for 5 days of trial. I would certainly hope brother counsel would waive the speedy trial aspect of things. If not, we're going to be really getting slammed with things that we just found out about today. So I would encourage, obviously you're a boss, for him to speak to his client now to see if we're going to waive that, because we're not going to waive that. That certainly changes a few things on our end.
Well, I'll consider with my client, Your Honor, but I'd like to have 30 days before I make that decision.
That's not going to be possible. When I look at my calendar, Mr. Lizigu, because if I move your trial that's currently scheduled for January 8th, 9th, and 10th, for 5 days, you are looking at frankly, even if I give you a backup to a previously scheduled delinquency jury trial, the earliest I can possibly give you is March 4th through the 8th.
May I speak to my client for a few minutes, Your Honor?